Effective feedback is important. In other words, you're stepping back and saying, here are the things that you did right. These are the things that need to be continued. Here's some things that need to be improved. Let's put together a plan for that. There's going to be promotions. There's going to be transfers. Sometimes you're going to have demotions. That happens. And these are the things that you need to follow up on as far as a manager is concerned and make some of the tough decisions. There's also going to be times when you're going to be doing dismissals. In other words, you may be firing someone for cause. There may be downsizings. In other words, the company is going through difficult times. One of the things they do is they cut back on the labor costs by letting people go. You may have layoffs. In other words, those are temporary. In other words, many times automakers will do a layoff because they're going through a model change. They're having to change the equipment and all of the other things that go along with that. People can't work. They get laid off. They're not being paid during those times. When somebody is leaving, you're going to do an exit interview. In other words, you're going to step back and say, okay, particularly when somebody is leaving on their own, why is it that you're leaving? What were the things that went well? What suggestions do you have for improvement? Many times, if you're going to have any kind of a layoff or a firing, you may be providing them, the person who's being laid off or fired, a package to help them move on to the next level or to the next stage of life, to their next job. Many times, in order to receive that package, they have to sign a non-disparagement agreement. In other words, I agree not to slam and say bad things about the company in order to get this. If they do, they can be sued. Now, there's a lot of rules, regulations, and laws that came about with labor relations. When we start talking about labor relations, a lot of times we're talking about unionization. Some of the laws that go along with this are the Privacy Act, Immigration Reform, and Sarbanes-Oxley, also known as SOX. You have a lot of laws that go along with compensation and benefits. So, for example, you have ERISA, the Employee Retirement Income Security Act, sets up the rules for pension plans. Okay, you have FMLA, Family and Medical Leave Act. In other words, you can have 12 weeks of unpaid leave without losing your job. You can have HIPAA, in other words, the Health Insurance Portability and Accountable Act, where you can have your health insurance plans transferred. You have OSHA, Occupational Safety and Health Act, which is to protect the employees. You have COBRA, Consolidated Omnibus Budget Reconciliation, where when somebody is let go, there has to be an extension of the health insurance benefits. Then you have the Affordable Care Act, also known as Obamacare, where employers with over 50 employees must provide health insurance, otherwise they're being fined. When it comes to equal employment opportunity, these are the big ones. In 1963, you had the Equal Pay Act, which basically said you have men and women in the same job with the same experience, they have to be paid the same. In 1964, you had the Civil Rights Act. Title VII of the Civil Rights Act was huge. It prohibited discrimination based on race, color, religion, sex, national origin. Sexual orientation has been read into it based on Supreme Court rulings over the past few years. You have the ADEA, the Age Discrimination in Employment Act, which says if somebody's over 40 years old, you can't fire them because they're too old. You have the ADA, the Americans with Disability Act, basically says you cannot discriminate against somebody because they have the loss of a significant life function. It also says that you must be able to provide reasonable accommodations. Now, reasonable accommodations means reasonable. Somebody's in a wheelchair. Let's say that their office is going to be on the 5th floor. The person might want a dedicated elevator for them that takes them right up to their cubicle. Well, that's not reasonable. So reasonable accommodations are important there. Those acts, those laws are designed to eliminate discrimination. Okay, discrimination is for some reason people are hired, fired, or whatever for reasons not relevant to the job. And there's two flavors of discrimination. You have adverse impact and disparate treatment. Adverse impact is basically an employment practice that results in unfavorable outcomes to a protected class. You may be thinking you're doing the right thing, you're doing okay, but it may be something that is having a bad impact on a protected class. For example, Griggs versus Duke Power. Basically, it was a power plant. They had a test. You scored above a certain level on the test, you got to work inside. You scored below that certain level on the test, you had to work outside shoveling stuff in the heat and the cold and things like that. What they found was the test had an impact that adversely affected minorities. So the test was determined to be discriminatory and was thrown out. Disparate treatment is basically intentionally treating people differently. For example, there was a famous case where there was a company that was doing work with countries in the Middle East. They were deliberately not hiring women to go to the Middle East to work for that company because the sheikhs and folks in the Middle East did not want to work with women. Well, the Supreme Court decided that customer preference is not something that can be used as far as hiring someone or not hiring someone. That was a situation where women were not hired. They were intentionally treated differently in that situation. That's illegal. Affirmative action was set up from the Title VII of the 64 Civil Rights Act, which basically says you, employer, must look for and try to find people who will fill some of these gaps. For example, let's say that you're a company and you're looking for engineers. You find that you have very low numbers of minority engineers. Affirmative action would say you expand where it is that you look. So let's say that you've been looking primarily in the Kansas City area and you're not finding anything. Then what you do is you expand that to maybe Topeka, Des Moines, things like that, to find those qualified individuals who might be minorities for your organization. Affirmative action is not hiring quotas. It is not quotas. What it is you're taking extra steps to try to find people for those particular positions. Sexual harassment is also discrimination. What it does is it violates Title VII of the Civil Rights Act, where you are discriminating based on sex. And there's two flavors of sexual harassment. You have quid pro quo and hostile environment. Quid pro quo is Latin for this for that. In other words, I'll give you a raise if you go out with me. Hostile environment is where you are setting up a situation that may be uncomfortable for somebody else. So, for example, nudie pictures posted in places. That's a hostile environment. You may also have situations of bullying, which is also discrimination. Any kind of abusive conduct towards someone else. If you are a victim of bullying, okay, here's some things the book talks about that you can do. Stay calm, don't strike back, avoid being alone, know your next steps, things like that. Now, with labor management issues, we're basically talking about unions at this point, all right? Unions are organizations that were formed to protect employees. In 1935, the Wagner Act was passed, which basically said unions are viable organizations. Now, before that, unions were considered a restraint of trade. And if you think about, Teddy Roosevelt back at the turn of the century and the trust busting and things like that, unions were basically torn apart because of they were considered trusts, and it was a restraint of trade. 1935, the Wagner Act said, you know what, unions are okay. And so it enabled unions to be set up, people to join, things like that. It set up the National Labor Relations Board, which would enforce the unions and collective bargaining that goes along with it. Collective bargaining is where management and the unions actually get together and put together the contracts for working in that organization. Now, the union movement has basically dropped quite a bit over the years. Unions were at their strongest back in the 50s. Today, there's only around 10% of the people who are actually members of union. Most of them are public sector workers. When you start thinking about the labor agreements, there's different types. Illegal is the closed shop. In other words, you have to be a member of the union in order to be hired. That is illegal now. A union shop is where you don't have to be a member in order to be hired. However, you must join the union after a certain length of time. An agency shop is basically where you don't have to join the union, but you have to pay the union dues because they're still representing you. The open shop is basically saying you don't have to join if you don't want to, and if you don't join, you don't have to pay the dues. That's called a right to work state. Kansas is a right to work state. With the unions and with the contracts, you're going to get different types of compensation. One of the things that's been happening over the past 10 years or so is what's called a two-tier wage contract, where new employees are coming in at a much lower hourly rate than the people who have been working there for a while. This has happened in the automotive industry. It's also happened in the airline industry with pilots, where people who are new are actually hired in at a much lower wage rate than those who have already been working there. There's also the idea of COLAs, cost of living adjustments. In other words, over a period of time, wage rates will go up. They'll get adjusted up because of the increase in the cost of living. Givebacks are where, during the negotiation process, the union agrees to give up something in order to get something else. Grievances are where you may be working, there may be an issue as far as the work rules, and you have a problem with that, you file a grievance, okay, to keep that from happening. Mediation is where you have somebody who's kind of like an umpire, okay, and you have two sides here. And what that mediator will do is try to get the two folks to come together as far as an agreement that both of them can live with. Arbitration is basically where you're saying, okay, you have a third party there, they're going to listen to both sides, and they're going to determine which side is right. So these are some of the key points from the chapter. I'm also going to be adding some other videos and things that go along with the hiring, with resumes and things like this. If you have questions, please give me a shout.